Finally, on the application of the law in practice, it is important to recall that no applicant is required to accept a friendly settlement proposed by the TRMC Ministry. Each applicant has the right to a reasoned decision after a full hearing. In all cases, the applicant has the right to appeal to the High Administrative Court and from there to this court. Mr. President, members of the court, the applicants imply that Turkey is relying on non-exhaustion to avoid its responsibilities under the Convention. Nothing could be further from the truth. The IPC was established precisely to ensure compliance with the court's decisions in Zanides Orestes. As the court is aware, there are a number of reasons why Convention rights are better protected by the resolution of applications such as these and the almost 1,500 other pending applications through domestic procedures rather than by the court. First, it is of course for the applicants to show that they owned property in the north of Cyprus or that their Convention rights have otherwise been affected. The court itself has said that it is sensitive to the subsidiary nature of its role and must be cautious in taking on the role of a first instance tribunal of fact where this is not rendered unavoidable by the circumstances of a particular case. I quote from the Tanlu versus Turkey case. The IPC, operating at the place where the properties are located and with facilities to gather evidence locally, is better placed to determine questions of fact than this court. The court will, for example, recall that in the Alexandru case, the applicant initially claimed to be the owner of 109 properties. After the facts were examined locally, she finally accepted that she was the legal owner of 7 and agreed a friendly settlement on that basis, a friendly settlement which this court approved. Second, many of the properties are now occupied by third parties, including some 40,000 Turkish Cypriots who have had to abandon properties in the south. Many Turkish Cypriots have been displaced from their homes several times. These too are persons whose rights must be protected under the Convention. The property situation in Cyprus is a problem for Greek Cypriots and Turkish Cypriots alike. As the UN Secretary General has stated, and I quote, "Property rights continue to be an extremely sensitive issue for both sides, and it is widely believed that only a comprehensive settlement of the Cyprus problem can bring closure to the property issue." End of quotation. In the meantime, the IPC, on the ground, is better able to hear from and take account of the interests of third parties than the court. Mr. President, members of the court, I do not need to recall the background to this complex and sensitive property issue in Cyprus. The issues are by no means confined to the north, but extend throughout the island. Much of the property in question is currently used by Turkish Cypriots. These are people who have twice become refugees in their own land. First after 1963, when they were confined to small enclaves for 11 years. Then again, 35 years ago, as a result of the Greek Cypriot coup and ensuing Turkish intervention. Turkish Cypriots should not again be deprived of their homes. The court, by recommending the establishment of the IPC, opened a path to solving property applications in a just and peaceful manner. It should be borne in mind that the decision in the present case could have a direct bearing upon ongoing negotiations for a settlement. Mr. President, members of the court, Turkey has cooperated fully and in good faith with the court in implementing the pilot judgment procedure instituted by Zenides Orestes. There would be serious consequences if the court were to decide to undo what it has done. Turkey and states in similar situations would henceforth have to think twice before agreeing to cooperate in implementing such procedures. There would be no certainty or foreseeability. Any such decision would also have discriminatory effects, as some applicants would be treated in accordance with the pilot procedure, while others would not. While the court is certainly entitled to change its case law when circumstances so require, we submit that it should not do so in the middle of pilot judgment procedures. Our submissions may be summarized in 7 propositions. 1. Pilot judgment procedures consist in a collaborative process involving the Committee of Ministers, the court, and the state concerned, aimed at solving systemic and structural problems going beyond individual cases. 2. The court has used the pilot judgment procedure for the 8 applications before you today. 3. Turkey has cooperated fully and in good faith with the court to bring that procedure to a successful conclusion. 4. For policy reasons that I've just outlined, for reasons of legal certainty, and in order to avoid discrimination, the procedure should not be interrupted. 5. The court should therefore allow it to continue. And 6. The domestic remedies, particularly judicial remedies provided for by such a procedure, must continue to function. And 7. These remedies must be exhausted if they are effective, which is the case here. We have shown, both in our memorial and this morning, that there is no reason whatsoever to abandon the track prescribed by the court itself in its earlier decisions. Not one of the applicants has even begun to test the remedies provided in good faith in response to the court's findings in Zenides Orestes. Not one has applied to the IPC, not one has appealed to the High Administrative Court. In conclusion, Mr. President, members of the court, the government of Turkey requests the court to decide that the applicant's claims are inadmissible under Article 35 of the Convention for failure to exhaust all available domestic remedies and to strike the cases off the list pursuant to Article 37. Subsidiarily, the government requests the court to reject the claims. Mr. President, members of the court, on behalf of the delegation of Turkey, I thank you for your attention.